Welcome and good afternoon. And it's so wonderful to see so many faces that we haven't been able to see in a long time and to gather together to honor Steve. My job today is going to be easy. There's no moderating this group. They know what to do. So I will get started. We will be kicking off the panel discussion with Kelly Bagby. Kelly is the Vice President and for Foundation Litigation at AARP. Bo Tayloe would be coming up next. Bo is the Deputy Chief Special Litigation Section, United States Department of Justice. And then we have our honoree coming up at the end with Stephen Schwartz, who is Special Counsel, Center for Public Representation. They will be talking for 15 minutes each. Guys, I apologize ahead of time, but I will set a timer and you'll get the alarm, so I won't interrupt you. And we will have time at the end for questions in this group. And I will ask for someone to tell me if there are questions from the online participants. So with that being said, Kelly.
Thank you. So I wanted to start by saying that in the audience is Elizabeth Jones, who was my mentor, who she and I started a pre-Olmsted case. We were doing deinstitutionalization litigation before Olmsted was decided. And it was about nursing facility residents in a psych hospital in Maryland. And we were desperately trying to get all of them out into their communities, but there was no network for them to go to. And that experience really was formative for me because it made me realize you have to actually build infrastructure to make sure that people who are deinstitutionalized can safely transition to the community. And that's really influenced a lot of the work that I've done over the last 25 years. So next slide, please. So first, I was going to talk about the relationship between aging and disability and the fact that kind of the why do people get stuck in institutions. I once had a journalist ask me, why can't your clients just walk out of nursing facilities? And I was sort of blown away because I was like, that just fundamentally misunderstands everything about institutionalization. And so thank you. So I really do think that we need to talk about the why, because not everybody embraces that. Not everybody thinks that, particularly for older people. I think everybody here would say a young person should never be in a nursing home, but an older person who doesn't need to be in a nursing home should also never be in a nursing home. We're going to talk a little bit about how Olmsted changed the legal imperative for all of the states and every governmental entity, and that they can no longer stick their head in the sand as a matter of law. They must take action. And finally, we're going to identify the ways in which Olmsted and the ADA help people to actually leave nursing facilities. And we're going to talk a little bit about how advocates really need to work collaboratively to address what are seen to be by states or said to be by states insurmountable barriers to deinstitutionalization, particularly now related to workforce. But there was always something. Today it's workforce, 10 years ago it was something else, 10 years before that it was something else. There always are going to be strong men that are put in front of us to say, this is the real reason we can't deinstitutionalize. And all of those strong men need to be knocked down. Next slide, please. So as we all know, there is a constantly aging population, which is a good thing. We want people to get older. But the problem with that is we don't have the infrastructure to support people in their home settings. We just don't have it. And we're doing very little to develop it. And in fact, COVID sort of made that even harder. And so we have to really be thinking about the numbers of people that we're going to be seeing as the silver tsunami, which I'm already in, hits. And we need to really be thinking about how do we build workforce? How do we build this imperative that it's not okay to institutionalize people? It's just simply not. And so when you have that imperative, then you will do things to build the infrastructure in the community that will allow you to not have to lock people away into institutions that they don't want to be in. As you can see from the slide, we're talking about numbers that are ballooning by 2060, which is really not that far away. By 2060, nearly 1 in every 4 Americans will be 65 or older. And we just don't have the infrastructure as people start to develop, in various kinds of needs that need assistance, various kinds of needs. And there are very few people who are entering the home care industry now. But that needs to change. That's because we're not prioritizing it. We pay better, we create better jobs, we create really a very robust and celebrated workforce. More people will want to do that job. Can you go to the next slide, please? Now here's the rub. Nobody wants to be in an institution. Nobody. Like really, there are 80% of people 50 and older when asked in an AARP survey whether they want to go into a nursing home when they become ill. The vast majority of them say no, they don't want to. The problem is we buy long-term care insurance, which doesn't allow for us in many places to not do anything other than go into a nursing facility. So we're constantly driving people into institutional care, which is a terrible way to prioritize aging in place. Next slide, please. So this is where we're going to talk about the imperatives. It is unquestionable that institutionalizing a person who doesn't need to be institutionalized is discrimination. It's just imperative that all of us have that as our first round argument. You just can't do it. You just can't. But then they'll say, well, here's all the reasons we have to. And so then that's where but you have to keep coming back to that first argument is you just can't do it legally. If a person can live in the community, then you have to figure out a way to allow them to live in the community. The governments can't, by contract or other arrangements, utilize methods of administering their programs that would tend to cause people to end up in institutions. This section of the ADA I'm using constantly because to me it's the easiest part to really help people understand. You can't administer your programs if you're causing people to tend to have to go in an institution. You can't allow for a more robust list of drugs in a nursing home than you have in the community, because that would cause people to tend to have to go into institutions. So you have a whole different set of things you have to do. And I'm going to talk about that a little bit in the litigation that we're doing. But the key to the ADA and to 504, but also especially the ADA, is it affirmatively requires that a jurisdiction must take action to allow for people to be discriminated against, which means they have to build the infrastructure to allow people to not be institutionalized if they don't need to be. It's really critical that we all as advocates think about how do we just keep pushing that burden back onto jurisdictions. It shouldn't be on us to say, you could do more, you could do more. What we have to say is, no, you have to say why you can't do more. You have to have the burden on you. I think we just go to the next slide, please. So AARP Foundation has done Olmstead litigation in the states up on the slide. We currently have litigation going in New Hampshire and in the District of Columbia, but we've had cases in each of these states over the last 15, 16 years. They're getting harder. They're getting harder. And states are less willing to settle than they used to be. All of the cases that we did up until the one in DC and New Hampshire, we settled. And these two jurisdictions just won't settle. They will not. We have had to litigate and litigate and litigate. Next slide, please. So there are two different kinds of Olmstead litigation that we do. It's the at-risk cases, so people who are at risk of going into institutions, and people who are already in institutions. And the issues that we've listed, a bunch of issues, and I think Stephen's going to talk about more of those same issues, so I won't spend time on it now. But if any of you who are interested in litigating Olmstead cases want to talk through theories, there are good theories and there are less good theories. And so we should, really, as I want to encourage people to bring more ADA cases, but we really, as advocates, we have to work together and make sure we're bringing the best arguments. Next slide. So I'm going to talk for a minute about Brown versus DC. That is Mrs. Brown, Ivy Brown. That's her during trial. We had to have a virtual trial, and she was in her nursing home, which is a terrible place in DC. And Larry McDonald, this was at the Protection Advocacy ULS's offices, and that's me sitting with him during his testimony. The case was brought on behalf of Larry and Ivy, and on behalf of thousands of other people in DC who want to move to the community, but they can't, because they can't just get up and go. They need transition assistance to rebuild their lives. Larry was in an institution for 17 years. He was 17 years in a nursing facility, and he had no ability to just rebuild his life. Ivy Brown has been in an institution for now, I think, 15 years, sadly. Next slide, please. Ivy's testimony at trial was just some of the most devastating and beautiful testimony. I've just put a bunch of clips here. You feel free to look at it your own self, but she talked about how terrible the institution was, how she never felt safe, how she couldn't leave her room because she felt like people would steal all of her stuff, that she just wants to go be in the community and just be able to wheel her wheelchair down the street. That's all she wants. Like, it's a simple desire. She's not looking for a fancy apartment or anything. She just wants to be able to wheel her wheelchair down the street. And this is the view actually out of her window, which is what she stares at 24/7, 7 days a week. Next slide. In DC, we went to trial in 2016. Our very mean judge said she didn't care about how terrible nursing homes were. She didn't care about, whether our clients were suffering. She ruled against us and said that the real problem here, she said DC didn't have a system. No question, DC had a system. But she said that the problem was our clients had a whole host of different barriers that were stopping them from being able to move to the community. And so she said, no, there are too many different things that are causing these people to be institutionalized. We appealed her terrible decision and got her reversed and remanded 3-0. No judges agreed with her. They all thought she was just made up a whole new standard. And that the Court of Appeals in DC said the imperative, people who want to live in the community and can live in the community are being discriminated against, period. So the only question is, what could DC do better to get them out? So we went back to trial and we had 2 more years of litigation. The Cole case we started in 2010, case is still waiting for a decision. So you can see this is what happens when jurisdictions won't settle. You just keep litigating. We finished our second trial in 2021. Next slide. So I'm going to talk a little bit very quickly here about using PASAR. PASAR is it should be a way to keep people from having to go into institutions. It should be a way to screen people to get services in their communities. It's often, unfortunately, used as a tool to cause people to go into institutions and then get special services in the institution. That is not the right way. And again, we can direct you to research. If you have PASAR questions, we have a lot of research on this. Next slide. The MDS is another piece that I think is really important. MDS is the minimum data set every nursing facility has to fill out for a resident. And there's a question queue that says, do you want more information about what it would be like to live in the community? And when you say yes, then presumably you should get more information about what it means to live in the community, which is not what happens, unfortunately. And so the question that we used in the Brown litigation is, what is the jurisdiction doing with all those yeses of people who want more information? And in the district, we could prove through unbelievable luck, we could prove they were doing absolutely nothing with the information that they got about the section Q. In fact, what they did was they would call the social worker in the nursing home who's already not helping the person move to the community and say, does she really want to move to the community? No, she doesn't. Okay, thank you. And they hung up. And that's all that was happening. For everybody. We had thousands of people who'd answered yes. Next slide. Thank you. So I want to talk for a minute about our New Hampshire litigation. That's an at-risk case. We have a case against the state of New Hampshire who is doing an awful job keeping people safe in their communities. These are people who are already in their communities on home and community-based waiver services. They're getting less, some people are getting less than 10% of the services they've been authorized to get. The state is authorizing them to get a whole mess of services, and they're getting less than 10% of those services year after year. And again, think of these are people who are nursing home eligible, so they're very complicated medically and fragile, and they're not getting any of the services they need. So we brought claims under the ADA, Medicaid, and due process. Can you go to the next slide? We filed it as a class action. We did get the class certified, which was a huge accomplishment. The judge first denied it and then granted class cert. We had to redo everything. Again, this is why it takes so long. And thankfully, we got DOJ to file a statement of interest in the case, which I think the court really appreciated. But we these are folks who are dependent on their caregivers for all their hands-on services. So if their caregivers don't show up, our clients have testified that they just will not drink water that day because they can't risk having a toileting accident, because they know if they have a toileting accident, they're going to end up in a nursing home. So they're dehydrating themselves day after day after day, which is complicating other medical conditions that they have. But this is their way of maintaining their dignity and their control. They're just sheer acts of absolute will that are keeping our clients in the community, just sheer acts of will. Next slide. Excuse me. The workforce is a huge problem in New Hampshire. It's the live free or die state for those of you who are not familiar with New Hampshire. Their taxation is abhorred. And so if there's not immediate money to increase the workforce, they're not going to do it. And so we spent a whole year trying to mediate the case with no luck. But we are, again, this is one of these cases that we're bringing based on the methods of administration claim, that they're administering that waiver in a way that's driving them into institutions at a very quick pace. And New Hampshire is also a state that is completely out of balance. They spend far more on institutional care than they do on home and community-based waiver services. So it just shows their commitment is not to deinstitutionalization, it's to re-institutionalize. Next slide. So that's my whole presentation. I look forward to questions at the end of this session, but I wanted to leave enough time for Ben and Stephen's excellent presentations.
Hello, everyone. It's a pleasure to be here. It's a privilege to be here on this panel. I know so many folks in the room as well. It feels like somewhat of a reunion. As it happens, I've worked on matters with everybody else on this panel at one point or another, and got a couple that are still cooking. So it's just great to be here, and I look forward to the rest of the presentations today. I want to start with just an overview. The U.S. Department of Justice has a couple of sections in the Civil Rights Division that focus on folks with disabilities and enforcing the Olmstead decision that Kelly was referencing. If you were to look at our docket right now, it would illustrate that nursing facilities are a prominent issue. Just if you could go to the next slide, it's just a current list of matters we have that are open as we speak, involving folks with various kinds of disabilities who are in nursing facilities. And our practice is broad. We look at a range of facilities, state-operated facilities for people with intellectual disabilities, mental health disabilities. Even in that context, we've got 7 or so that are in the works as we speak. It's a very big issue. All it takes is the wrong set of circumstances to go from living in your home to being in the hospital to being sent out the back door, so to speak, of the hospital and into a nursing facility, often with folks having absolutely no idea that they have a legal right to receive services in the community. Stephen and I have a case pending in Texas in which someone with cerebral palsy had been living independently and then his father died, and the result of his father dying, even though this guy was in his 20s, was off to the nursing facility with you. And he was destined to spend the rest of his life in bed. They didn't have a chair for him to get out of the bed until our litigation. So we get that this is a huge, huge issue. Next slide, please. I want to talk about 2 aspects of this issue. The first is something that will dovetail with what Stephen's going to cover later. Kelly sort of set the stage. We have this litigation. We identify that folks' rights are being violated. Stephen's going to talk about remedies that are reasonable accommodations, reasonable modifications in the service system that would help break this cycle and allow people to remain in their own communities. One of the things that comes up when states are faced with litigation from systemic litigation like we're talking about today is an affirmative defense. Under the law, even if you can establish that a state is systematically, or a jurisdiction systematically violating folks' rights under the ADA to live in the community, they have a kind of a remaining affirmative defense. They can argue that may be true, but it's not for the courts to fundamentally alter the way we go about business. You can't fundamentally alter the service system. And so the task of plaintiffs in bringing this litigation is to demonstrate at the right moment, you don't need to do it out of the box, but at some point or another, that what you're looking for is along the lines of a reasonable accommodation. And Stephen will get into some specifics about that. But one of the ways that a state can say, hey, we've got this under control, don't ask us to change anything, is by having what's known as an Olmstead plan. The Olmstead said, in effect, a public entity can show that it's got a comprehensive and effective plan to serve folks with disabilities in the community. Well, that's a way for it to put off having to do any further modifications to its service system. So Olmstead plans are very much an issue in our litigation. So if you could go to the next slide, please. The existence of the plan by itself is just the starting point, however. And there is a lot of good case law that makes clear some of the critical points. The plan has got to involve a measurable commitment to deinstitutionalization. It's got to have specific goals for community placement. And it's actually got to move people to integrated settings and reduce the number of people who are in institutions. This is from cases around the country that have made very similar points. I want to underscore one aspect about this. Sometimes in response to an investigation or the start of litigation, a state will make efforts to shrink the population of people it's serving in an institution. Well, that could be well and good. That could be a good thing. But a state, as you look at the last bullet on this page, or the middle bullet, they've actually got to move people to integrated settings. It's not enough to dump people out of institutions. They've actually got to connect them with services. And the Olmstead plan requires them to do that, to actually connect them with community services. And that may well play out for DOJ and some litigation down the road. We'll see. Other aspects of an Olmstead plan are that it's got to be concrete, reliable, and involve realistic commitments with specific and reasonable timetables. It's got to be a real process that is actually moving people from institutions successfully into the community. And they've got to be held accountable for it. It can't be just a representation. They actually need to be held accountable to implementing that plan. Further, it's got to address specific groups of people. It's not good enough to have an Olmstead plan that covers folks with this kind of disability, but not that kind of disability. The plan needs to address the folks who are currently being discriminated against by being segregated in institutions. And it should actually should demonstrate reductions in those groups living in institutions. So if you could go to the next slide, please. What an Olmstead plan isn't, what doesn't constitute an Olmstead plan is a negligible decrease in an institutional target population. So if it's just marginal, that's not going to cut it. Another aspect of what an Olmstead plan should not be is vague assurances of future integrated options. I work with a monitor in one case who has years of experience as a state employee. And one of the lessons he's made clear to me, at least, is states are real good at planning and real good at process and policy, but maybe not so good about actually achieving outcomes. And so these last points from the case law reinforce that you just can't talk the talk. You gotta walk the walk and achieve results for people. So states have this defense. They have an affirmative defense option called an Olmstead plan, but it is by no means a get out of jail free card. In many respects, that plan can be a mechanism to hold states accountable, either in the litigation itself or at a different stage. The next slide, please. The next topic I wanted to cover is sort of an emerging issue, at least for the Department of Justice. Many of you may have already encountered this in one context or another on an individual basis. But we at DOJ are developing a deeper understanding for the problems for institutions or institutionalization around guardianship. The use of guardianship processes to facilitate people going into institutions. And so, to take an example, when a person with a mental health disability is frequently going in and out of the hospital or not engaging in treatment, and is one option in some states is to say, well, we're gonna get a guardian for that person, often a public guardian. And if that public guardian doesn't have a way of accessing or helping that person connect with community-based services, then often that public guardian will say, well, then the option for you is a nursing facility. They can keep an eye on you. They'll make sure you take your meds, those kinds of things. We have an investigation involving the state of Missouri where public guardians have filed petitions that have resulted in hundreds of people going into nursing facilities for exactly this reason. And as one provider said, it's a sentence. It's like a prison sentence when this happens. So guardianship, we'd love to learn more from you if you've got experiences with that, but it's on our radar. It's for us an emerging issue. To Kelly's point earlier, it's another way that systems structure themselves in a way that facilitates institutionalization these many years after the ADA was passed and the Olmstead decision came down. Ways to tackle guardianship, if we could go to the next slide. One of the lessons I've learned from Stephen is to try to avoid getting into the decision-making process of an individual local judge. Judges don't like to be in a position where they're second-guessing another judge unless they're an appellate court. And if you were to take on guardianship decisions on an individual basis as a way of getting relief, it might work for your particular client. That's not saying you shouldn't do that. But from a systemic perspective, you don't want to be seen as screwing around with the individual determinations of a state process. But there are ways you can get at it. You can get at it upstream and you can get at it downstream. And those are what I want to talk about as ways to pursue the issue. Next slide, please. So one of the ways is to, if you are able to establish that a state or a jurisdiction is violating the law and you're at, back to what Stephen's going to be talking about in a little bit, remedies. One of the remedies that you could pursue is that a state can't make or should not make the fact that you're non-compliant with your medication or mental health treatment alone as a justification for the imposition of guardianship. That you need more than that. That's not a default, guardian comes in, off you go to the nursing facility. Second, you can help divert someone from guardianship and institutionalization through enhanced efforts, extra efforts, if you will, to connect that person with community-based, more intense community-based services like Assertive Community Treatment Act, or other services that can help that person live successfully in a community setting. And again, at the front door, you can say, well, you don't have to go from 0 to 60, going straight to guardianship. There are intermediate mechanisms that allow people who care about individuals to support them in a way that doesn't strip them of their legal rights. And the prominent one is supported decision-making, where you come together, it's a more limited arrangement. It allows you and allows the person to have supports in the community for you to help them make good decisions that will let them stay successfully in the community. So these are front door ways to divert the guardianship track. Next slide, please. There are also back after the fact, after the guardianship is imposed, options that could come into play too. One is, and I realize Kelly's alluded that the default with MDS, question Q is often this paper exercise that doesn't result in meaningful change. But if you're in the context of an agreement where you've got strong oversight, actually requiring that a case manager or someone from an assertive community treatment team engage with the individual on a regular basis about exploring alternatives to make sure that, Stephen's going to talk about this, you've got a meaningful and informed choice of real options. Then you might learn that the person is ready to seek termination of their guardianship, and that there are other options that the person can go to that would give them more independence and also lead the way to them leaving the nursing facility. And then the next option is actually exploring on a cycle, on an annual period, a termination of guardianship. Guardianship isn't going to last forever. We're going to look at this periodically on a schedule, and the need for guardianship needs to be reestablished. That's particularly important in the mental health context because folks can be at different stages of their life at different points, and at one point they can be thriving, at another point they could be experiencing difficulties. But the fact that at one point they're experiencing difficulties doesn't mean that a guardianship needs to be imposed like a life sentence for onward. Again, maybe in questions or later we could chat, but I'd like to know more about your experiences with the guardianship issue in particular. It is definitely on our radar, and we're going to continue to look for opportunities to tackle that issue. Thanks very much.
Next. So most of the cases that CPR, where I work, involving nursing facilities, and many of the cases that DOJ brought as well, were about people with a single disability, intellectual disability, together with folks in Massachusetts, and then with DOJ in Texas, we challenged the unnecessary institutionalization of people with that disability. And then CPR moved to people with brain injuries. And there are other cases. Next slide. Okay. I do have a soft voice, purposely so. So the cases that many of us have been bringing have been limited to people with a single disability. And there were good reasons for that, because at the outset of the Olmstead case, the application to nursing facilities was less clear. They were private operated facilities, and they were operated also by various different agencies. But I think it's time, especially because of the pandemic, that we shift the focus and think about a cross-disability case. In Massachusetts, 1 out of every 7 people who died lived in a nursing facility. And of those people who died, they were disproportionately Black and brown people, because nursing facilities are disproportionately accessed by low-income people and people of communities of color. So it's important now, if not urgent, as a result of the pandemic, that we shift the focus and think about a cross-disability case. The big problem with a cross-disability case is that states are generally organized around disabilities. There's a Department of Mental Health, a Department of Disability or Intellectual Disabilities. So they run facilities, and then they run community programs that are siloed to people with a particular disability. So bringing a case that tries to cut across that spectrum is a significant challenge. And so we just tried doing it, and we have successfully settled the case without having to prove some of the very difficult principles that I just want to go over a little today. The first strategy, I think there's 5, next slide, 5 key framing questions that advocates need to think about. First, how do you describe that segregated system? Who are the plaintiffs that you're going to use? Who are the defendants you're going to sue? How are you going to ensure that people can make meaningful choices of whether to leave those facilities? And what kind of relief or remedies are you going to seek? Next slide. Starting with the first, I think that most important, you have to describe this system, the system that is segregating people without regard to their disabilities, and the service system, the remedy, the solution, as a single system. That single system can be called the long-term care system, the community service system, but we can come up with words that are framed around a single service and a single system. And not surprisingly, nursing facilities are inherently cross-disability institutions. It doesn't matter what disability you have, you can get into a nursing facility. They don't give you services that are specific to your disability, to your physical disability or your psychiatric disability or intellectual disability. You're admitted without regard to your disability. You're institutionalized and kept there without regard to your disability. And so nursing facilities inherently are across disability institutions that are created, funded, administered, operated, and overseen by a single entity, the government of that state. Now, when you choose the same problem about reframing the case around cross-disability applies to the plaintiffs. Next slide. It's important to include people in your group who have different disabilities so that both the judge, the defendants, the media, and everyone else who's going to pay attention to your case understands this is not about a single group. It's not about people who have one particular condition. It's important, I think, to focus on the commonality of disability because it is that commonality that's causing the institutionalization in the first place. And so you can emphasize that the difference in disability, serious mental illness versus intellectual disability versus people with spinal cord injuries or brain injuries, that's not the reason for their institutionalization. Their reason for their institutionalization is irrelevant to the particular disability. So in our nursing facility case in Massachusetts, we defined the group as including all adults with disabilities who were in a nursing facility for a period of time and had not been provided the critical remedy being another place to live with supports. Another place to live, that remedy we'll talk about in a second, also needs to be framed in a cross-disability way. Turning, next slide, then who to sue? Because the agencies in most states are organized by disability, if you just do the director of mental health or the director of disability services, you're going to be re-emphasizing the wrong narrative. So you want to be able to select as the defendants the people who are above the specific agencies, the governor, the Secretary of Health, the Secretary of Human Services, the budget director. Those are the people who have developed a long-term care system that prefers institutionalization over community opportunities. And while it may be important to include as other defendants, people who are running the agencies so that you can get the right information, so you can have an order against the right person, you want to make sure that the frame all along is across the state's responsibility for running these services. Let's talk now, next slide, about the remedy. No one, as Kelly says, really looks forward to going to a nursing facilities. This is not an aspiration that most of us have. It's actually a fear. We're worried about that. We try to buy insurance and make sure our kids have a place where we can live so that we don't have to go to a nursing facility. Yet, because of a lack of supports or other reasons like that, people start thinking, families begin to believe they have no choice. And so it's the lack of choice on the front end that causes the institutionalization on the back end. And so what we need to do as part of our remedy, part of our case, is to create a choice process, to create an opportunity for people to decide, do they really want to go there in the first place? And if they're stuck there already, like Kelly's plaintiffs, do they really want to remain? Because you need, if you are going to stay in a segregated institution, you need to be able to make an informed choice to do that. An informed choice must include a meaningful option. This is like that great phrase from the grandfather, we're going to give you a choice that you can't refuse. That's what the community would be. It's an option that people wouldn't want to refuse. And so it's important then, because of the way that states are organized, to create a choice process that itself is cross-disability. that is not dependent on what condition you have, what agency you might be assigned to, what community network they're operating. And that choice process will have to include some types of accommodations or modifications. Next slide. Most of us know that under the Supreme Court's decision in Olmstead and under the ADA in Section 504, states have an obligation to make changes to the system to accommodate people's disabilities. Most of us have not thought, though, about the changes they must make to the choice process, the way that people decide where they're going to live and how long they are going to stay there. So the obligation to make modifications seems to me the first starting point for a universal choice remedy. And that obligation includes not just providing information. In one case that I did, the state made a big deal that they had hired a person with a brain injury to be in a video. And they would show the video to other people in nursing facilities. And that was the accommodation they had made. Right? They didn't bother to ask whether the person in the nursing facility who had the brain injury could understand and appreciate the video. They more importantly, never asked, why did that person with the brain injury go into the nursing facility in the first place? Had they been scared? Had they thought they had no alternatives? They didn't bother to ask how long the person with a brain injury in the nursing facility had been there and whether he or she had begun to develop some fears or concerns or anxiety or trepidation about moving to the community. Or did they have a guardian who believed they needed to be in an institution in order to be safe? So the obligation to make a reasonable modification to the choice process most importantly involves experiences. It involves the experience of community living, not just a brochure or a video or even a conversation. Bo and I did a case in Texas in which one of our experts talked about what was necessary to give people with significant intellectual disabilities choices. And he said, people with intellectual disabilities learn best by doing. And so if you give them a brochure that they're going to read or even a conversation that they will listen to, right, it will not have the same kind of learning impact as taking a walk downtown, having a choice about where you're going to have breakfast or lunch or dinner, where you might shop, and what that experience of community living is really about. Next slide. In addition to making modifications to the choice process, there's a separate obligation, I think, to be able to undo and address the vestiges of institutionalization. 60 years ago, in Brown versus Board of Education, the Supreme Court recognized that it was not enough to just allow Black kids to go to school with white kids, that this segregation that had existed for 100 years or more had impacts, structural racism impacts on communities, on people, on families, and on their choices. And it was the vestiges of that segregation that had to be undone by a school system. And so too, that same process, that same indication, that same criteria needs to apply in nursing facilities. Elizabeth Jones did a case in New York together with Bazelon Center and the Department of Justice, in which the judge adopted an explanation or created words that I think she suggested to him about the effect of institutionalization. He called it learned helplessness. That people began to get up every day and they were told when to eat, they were told where to go, they were told when they were allowed to brush their teeth. So they began to learn to be helpless. What we're trying to teach in Olmstead is exactly the opposite. So the obligation in a choice process for a state is to undo the impact, the effect of that learned helplessness. And in doing so, they must find a way to make sure that the vestiges of institutionalization, the hours, the months, and the years that people have spent in nursing facilities are accommodated. Next slide. So what do people need in addition to choice to get out of nursing facilities? It's pretty simple. They need a place to live with some support. And the place could look a little different depending on their needs. The degree of support could look a little different. Does it involve nursing or physical therapy? A variety of different sort of support services, but they're not that complicated. They're being administered and developed and implemented in most states every day. Right? But for some reason, and Kelly knows this a little painfully because she had a judge who said, well, what they really want is housing. And housing is not kind of covered under the ADA. It's a sort of a different agency with a different problem. As a lot of us need housing. Many of us can't get housing because we can't afford it and so on. And so that's not part of disability discrimination. So rather than get into that argument, what we did in Massachusetts was just say, what people need are residential services. That's what a nursing facility is. It's a residential service. That's what the Department of Mental Health and Developmental Disabilities provide all the time and have been doing so for decades for people with those particular disabilities. And so in the same way that you want to say that residential services are, like I said, disability blind, meaning that it doesn't matter what disability you have, you need a residential service. Support services are also disability blind. So what we did was in our nursing home case, next slide, develop a broad definition of residential services that include small staffed homes, supported housing, subsidized housing, rental vouchers, in-home staff assistance, nursing support, home modifications so people could move in and out of their bathrooms and up their stairs. And then finally, next slide, we wanted to make sure that the agencies, that the services, the residential services were framed, were created, and were delivered in a way that you didn't have to prove you had a particular condition. You only had to prove you were in an institution, nursing facilities, and you didn't want to stay there. And so Massachusetts, in our settlement, has created several different disability blind programs, waiver programs, money follows the person, and a few others. Last point I want to make, next slide, is that because nursing facilities are disproportionately used by Black and brown communities, remedies that get people out need to be culturally competent. We need to think about developing community services for people who are from Haitian, Laotian. Massachusetts has a number of Asian communities. And so where the people are speaking Laotian, we need staff who can speak Laotian. We need community programs also that are run by our communities of color and by various different linguistic and other communities. Because if we can find a way to take the money that was being used to operate these institutions and move it to the community and at the same time support and grow culturally competent community-run organizations that don't worry about the type of disability. They worry about what language you speak, what color you are, and how to be able to accommodate your different needs so that the staff is trained, the staff in a culturally competent way. The services are back in the communities where people came. They're not moved to the other end of the state. They can move back to where their churches are, where their families are, where their schools were, and where their mom and dads are. Thanks very much.
Okay, great. Thanks, you guys. Great panel. Any questions, comments? Yes.
One question, how do we get rid of the requirement that you need to be at ICF level of care for HCBS? As somebody who doesn't get HCBS, who's been denied numerous times.
Can you?
How do you get around the requirement that you've got to meet an ICF level of care to qualify for HCBS services?
Because that's the thing that they say, you need to be at risk of institutionalization. You need to have that to be at risk of institutionalization, nursing home level of care. Yet, as somebody like me, all I'm looking for is like 3 hours case management, home support, 10 hours a week or so. I've applied DDA services in Maryland numerous times and I keep getting denied.
Actually, we had litigation in Maryland about the eligibility criteria for HCBS, in part because they had basically a heightened requirement for how you get into HCBS. It was higher than nursing facilities. And so we sued. And so we should, we're happy to talk to you. I don't see it as a detriment that you have nursing home level of care to get to HCBS. I see that as a tool. Because then you've already satisfied that you're eligible. It's the same eligibility criteria, makes it easier from a legal perspective because you're eligible for both. And if you're eligible for both, then you should be in the one that is most integrated.
And they keep on saying, oh, you don't meet that criteria. Yet I had HCBS when I lived in a state like Vermont, which many people say it shouldn't matter. If you're eligible in one state, you should be eligible in another state.
That's an interesting point. I mean, I think we should talk about it. I'm happy to talk to you about it.
Awesome.
Yeah, I love suing Maryland.
Yeah, my question is this: what for people with disabilities make the right decision for them? And people got to start telling them, letting them know. Like if they say the doctor say you have to go to a nursing home, for instance, let them know that if you're in a nursing home for more than 100 days, you lose everything you got. You lose your house, you lose your car. If you're on land, you lose that, or what have you. So set it up so people that want to keep what they work so hard to have, set up so they can like say, well, I just want to be there for 2 months. After 2 months, I'm going back home. And I can have the aides or whatever come to my house to help me. What have you? I can have the physical therapy come to my home. Because it's cheaper for physical therapy to come to your home and help you than it is for you to be in a nursing home receiving physical therapy.
Yeah.
So they need to know that. And also the people in different agencies that might run like group homes or helping somebody in their private home, they need to know not to tell somebody to go to a nursing home because the doctor said so. You see, a lot of times in the community, we are taught to obey. We're not taught that we have the right to say no. We are taught to obey other people. So the people that run the facilities, group homes and others, got to be told not to tell somebody to obey somebody because they said so. Because I went to, I had a relative that was in a nursing home. And like, I went there, they had a party for this hospital that was nearby the nursing home. So I went to the party. They tried to keep me from going in there. I said, my loved one is in this nursing home. You don't tell me where to go, okay? And like, they was passing out envelopes to different doctors and whatnot that was in there. And then I wound up finding out from somebody else, I don't know whether I was true or not, that it was giving out money for doctors to recommend that nursing home to other people.
Yeah, I think
so they don't really give out choices, even with medication. I'm sorry. Even with medication, they prescribe medication for you, don't even tell you the side effects. When you ask for them to tell you the side effects, they say, oh, just take it. I'm like, who are you talking to? I need to know these things.
We've got one question in the back. Liz, and I'll just come back to you guys too.
Thank you all for taking the time to us today. My question concerns guardianship, which I was supposed to about a year ago. In particular, you kind of presented the interplay with the recent, and I'll share it with saying, unfavorable decision where at-risk security service, right? How you mentioned that it's a better idea to attack the process of getting people getting institutionalized as opposed to individual guardianships. But I'm wondering how we can kind of do that without resorting to demonstrating actual
So there are a couple different aspects to this. Starting with avoiding the at-risk issue, you can still deal with the fact that systemically folks shouldn't be relegated to guardianship for the rest of their lives. That there have to be processes that give people options. And the way to build that case is to show that there are a lot of folks who don't want guardianship, who don't necessarily need guardianship, who are interested in receiving community services, have not been given a meaningful opportunity to explore those. It's quite common. It is a quite common fact pattern. And work out from there, because then you're not dealing with the at-risk piece. They're actually institutionalized. But, we're not backing off of at-risk. We know that there's an unfavorable decision in the Fifth Circuit. There was a decision that came along not long after that one, not long after U.S. v. Mississippi and in the Fifth Circuit that kind of backed off a little bit, some aspects of that, which was a nice statement. That's still the law only in the Fifth Circuit. And so we are by no means backing off of the serious risk of institutionalization. There are different ways that this can be addressed from a purely serious risk of institutionalization perspective. There are arguments that when you have people who are already in an institution, the relief you get should not be limited to those folks. The relief you get should be, it's equitable relief, it's preventative relief. It should encompass people who may come into the institution later, that's within the ambit. Separately, the fact that folks who can't get access to services except by being institutionalized, that's a form of they're having to forego services that you're otherwise qualified for in the community is a harm. And whether or not, it's under the umbrella of serious risk, you're already facing a denial of your rights under the ADA when you can't get the services you need in the community. You have to either go without or go into an institution. So those are some of the ways that to tackle the question you brought up.
I think one other thing to keep in mind is that you should approach any guardian that is misbehaving and pushing people towards institutionalization and remind them what their responsibility is. Larry McDonald, our named plaintiff, the nursing home got a guardian in the course of our litigation to basically try to kibosh our case. And we just went to the guardian, we're like, let us explain to you what your responsibility is here. You're supposed to fulfill his will, and his will is he wants to get out of this institution. And we had to work with her a lot, believe me, a lot, to make sure she understood that is her statutory responsibility. But you shouldn't assume that a guardian knows what they're supposed to be doing, because they usually don't.
We had, okay. Serena, we had Liz and Tia, then and Val and Serena, and then there was one in the back too. So.
Maybe I missed this, but I'm Liz White with the AARP. My question is, if people listen to elderly people who want to get out of the nursing home, why won't they listen to people with disabilities? There are so many people with disabilities who are placed into institutions because of their character or whatever. And when I ask anyone, why do they listen to people who are elderly and they can listen to us?
I have to say, I don't think they're listening to anybody who's elderly either. And I think that's part of what we're trying to do, is help to promote that they should listen to everybody. Anybody who is in an institution should be heard and has to be heard. And I think it's critical that you ask those questions. But I think the problem is when you get into an institution, you are basically stripped of your identity. and you're stripped of your voice, and they become unable to hear you as they should. And I think that's part of the role of advocates and like you and all of us to try to promote those voices and make sure that nobody can just pretend they're not hearing people.
We're running. We've got time for one more question, and then can you guys grab the panel members during break? Keep the conversation going. I just want to keep this on time. So you've had your hand up for a while.
A little bit about the litigation in Louisiana and what some of the issues that you've been seeing arising. Well, Louisiana, we've had to sue a number of times, as has DOJ. And Louisiana is, we've had a number of class actions against Louisiana around nursing facilities and people at risk, especially people with mental health needs. But it was the first case that we did was Pitts v. Greenstein. And in that case, there were people who were in the community already, and the state had made a decision to cut by a third all of the services everybody was going to get, without regard to whether that was going to cause everyone to have to go into nursing facilities. So we were successful in stopping that in that case. But I think that Louisiana is always at the tipping edge of either being sued or needing to be sued.
Well, thank you so much to our panelists. Let's give them a big round of applause. I know there were a lot more questions out there. I think, as Melanie suggested, if you can pigeonhole some or buttonhole some folks out in the lobby during the break, that would be great. We have 15 minutes. We'll get started with the second panel on memorializing the history and legacy of institutionalization at 2:30. So don't go far.